Item 58 of supplementary list, judgment.
The court, after having considered the matter in its entirety and is also of the considered opinion that the deduction of pension amount paid by the government of Nagaland to the petitioner by REC Silchar is illegal. Accordingly, REC Silchar, now NIT Silchar, is directed to refund the full pension amount deducted from the salaries of the petitioner from the date she joined in the REC Silchar till her retirement on 31/12/2024 within a period of 2 months.
59 of supplementary list, judgment.
Dismiss.
Mentions may be made.
My lord, I have a prayer in respect of item number 55, my lord. This matter would, my lord, apparently take some time, and considering the long list, and I have some constraint today, my lord, in the second half. So can it be taken up next week, my lord? I've taken consent from the other side, Mr. Sharma.
Next week, there'll be some problem.
My lord. Then any date thereafter, my lord.
Item,
Item 55, my lord.
arbitration.
Arbitration. This is relating to appointment, but then some issues relating to applicability to third party who are not bound by the agreement is there, my lord. So
Okay.
therefore, it has lingered, my lord, this matter.
Who appears for the petition?
Mr. Sharma, P. Sharma,
Yeah,
Pranjal Sharma. I have intimated, my lord. In fact, he is also unwell today.
On request made by Mr. P. Pathak, Learned Counsel for Respondents, 123.
My lord.
When do you want?
My lord, any convenient date, my lord.
14th? March?
14th, my lord. 14th, my lord. Simply out.
My lord, in item 44-45, I filed an affidavit of position, my lord. Record may be called for, my lord.
40?
44-45, my lord. Affidavit is filed only yesterday evening, not in records,
Then maybe they're verifying it.
my lord. That is why. So Monday maybe fix, my lord. I can attach with these reports, my lord. Then it will be your
Where
lord.
is Bhuyan?
Bhuya is not there. I will inform. And
Let-
actually, SP Chaudhuri is NIT Silchar, and
No, the petitioner's counsel.
is I am MJ Burwa, my lord, myself, and Bhuya is another councilman, 44 and 45, my lord.
Yeah, Bhuyan is counsel in a.
Same. We are same, my lord. We are to NIT as union, and he is an for 10 writ petitioners, my lord. We are same. Yes. He is also there.
You are appearing for Bhuyan.
Yes, Bhuya.
You are appearing for.
My for NIT union, no. NIT
What
Workers
did you file?
Union.
You file your affidavit and reply
Yes, reply, my lord.
to the counter filed by the respondents.
Yeah.
Okay, Mr. M.G. Barwal and a counsel for the petitioner in WBC 5406 of 2023 submits that he has filed an affidavit in reply to the counter filed by the respondents on yesterday.
Yes, sir.
Yesterday was what date? 28. Registry to verify and place the record, place the same on record and list the matter after 2 weeks. After 2 weeks.
Unless.
Wait, please, Lord. Wait, please, Lord. Rashid, I beg to mention a motion matter for tomorrow.
What?
The matter pertains to transfer. The officer has a disabled dependent who is squarely covered under debarring from rotational transfer. Those grounds were taken any earlier round of transfer which was stalled. Somehow he has been sought to be transferred again. The relieving letter has not yet been issued. And once that happens, your lordship rights might accrue. So tomorrow, if your lordship may please to fix the matter. I'm grateful, your lordship.
Motion bring for listing of a petition for admission, Lordship. Any day next week.
Next week, there's some constraints. 13th.
Lordship.
Lordship, I beg to mention for listing of request for admission, Lordship. This matter will be listed on next week.
18th.
May I please? Lord, item 57, my lord, hearing matter, my lord. Today, my lord, I have some personal difficulties. My lord, can it be posted on 7th of March, my lord?
7th will be difficult.
Then any convenience given.
On request made by Mr. Emily Mondal, the head counsel for the petition. List on 19th March.
My lord. Deep law, please.
Item 16 of daily list, admission.
May it please your lordship. Lordship, this is actually a part-heard matter. Both of us had finished and the finance department wanted to rely on something, but we have not received so far. Lordship, what I did was made a written submission just to recapitulate and make it quicker. May I, Lordship?
You are for,
I am for the APDCL.
who is this finance?
I think it's respondent number 2.
Even otherwise, because the APDCL is
Yeah.
a separate entity from the government of Assam.
Hmm.
Finance would not have the stand of the finance would not have any bearing on this
But
matter.
last occasion, finance. wanted
Yeah,
to-
he wanted to tender something. He did not have copy, which is why I was supposed to give my rejoinder, but he said, I don't have a copy, so it got adjourned. But we have not received the copy yet. It's been now 3 months and he's not here. So I think
His name is reflected.
It-
Finance is reflected.
Asana? Further
Otherwise, the
issues
Yes.
between APDCL and the petitioners.
finance is more like finance on the side.
Okay. It was heard quite long time.
Yes, Your
Yes.
Lordship, which is why I thought it's easier if I
Oh,
formulate in a submission, then it'll be easy to recapitulate. Because it was really my
then
rejoinder.
why don't you submit your arguments?
I have prepared, your lordship.
Okay.
So Lordship, petitioners are grade 3 employees. We were employees of ASEB, Assam State Electricity Board, the original electricity board under the state. And we were appointed before reorganization. So Lordship, we are grade 3 APDCL. Sorry. No copy. Okay. Huh? Happening. And we were appointed before, I said before 9/12/2004, because that's the date of the agreement. We were appointed as ASEB employees. So we belong to ASEB before reorganization, and then reorganization happened, and now we are now in APDCL. Because Lordship knows ASEB was reorganized into 3 departments, 3 different companies: distribution, transmission, and generation. We belong to APDCL, one of the companies now. We got hived off to one of the companies. Lordship, I have extracted all the relevant things in the notes, so we don't have to go. Paragraph 2, Your Lordship. There was a tripartite agreement. And the issue really arises because of this particular reorganization. The reorganization of ASCB into 3 different companies of ASCB. So what are the terms and conditions of services that we will apply to us, considering we were of the erstwhile ASCB? So there was a tripartite agreement, Your Lordship, and the tripartite agreement was, Lordship, I've given the page, it's page 27. It was between the state government, ASCB, the erstwhile company, and the registered unions. Lordship, may I read the preamble? Lordship, this document is at page 27. Would you like to read from here only, or should I take you?
It's up to you.
Lordship, you're fine with this? It's extracted verbatim. Whereas the state government has declared its policy of restructuring the electricity sector and is notifying the transfer scheme under Section 133 in accordance with the Electricity Act 2003 for purposes of restoring the operational and financial viability to meet the future demands for sufficient supply of energy, provide quality service to consumers, and to bring out the board from present revenue deficits. Number 2, this is important, Your Lordship. Whereas the employees, which is us, Your Lordship, we were employees, representative have expressed apprehension that there would be adverse effect on their service conditions and retrenchment in services resulting loss of employee. Whereas the state government has stated that such apprehensions of employees are unfounded. It is for this purpose that the agreement was brought into being. Therefore, in exercise, it is agreed to by and between the parties as follows. Lordship, I have only quoted the relevant ones. Number C, the terms and conditions upon transfer to the successor entity shall not be in any way less favorable than present terms and conditions under ASCB. In fact, endeavor would be to rationalize the terms and conditions to provide for reasonable career growth and other wage measures more beneficial to the employees, recognizing that the employees are essential part of growth power sector and its operation in an economic and efficient manner. Any change of existing service conditions such as seniority, promotion, transfer, leave, pay allowance, etc. shall be regulated by the existing service rules regulations in vogue unless it is modified by mutual consultation and mutual agreement. So Lordship, the important thing is terms and conditions on transfer shall not be in any way less favorable than the present terms and conditions. Lordship, J, all benefits of service rendered by the employees in the board as on date of restructuring shall be protected and shall be given full effect. Lordship, this is actually not so different from what the mandate of the law is. Lordship, may I take you to page 42? Because the whole section is there. And the case hinges on interpretation of Section 133. And from what my learned friend argued, we're pretty much on common ground on what the interpretation should be. So actually, Lordship, the 2004 agreement is actually in line with the mandate of the law under Section 133. Section 133 is, Lordship, 131 of the Electricity Act talks about reorganization, what happens. Then Section 133 says what are the provisions relating to employees of the old board. So Lordship, may I read? Section 133(1). The state government may, by a transfer scheme, which I showed your Lordship, that is the transfer scheme which I just read out. Provide for the transfer of officers and employees to the transferee on the vesting of properties, rights, and liabilities in such transferee as provided under Section 131. Number 2, upon such transfer, under the transfer scheme, the personnel shall hold office or service under the transferee on such terms and conditions as may be determined in accordance with the transfer scheme. Now, what is most relevant for us is the proviso, because everything hinges on this. Provided that such terms and conditions on the transfer shall not, Lordship, the words are shall not in any way be less favorable than those, Lordship, which would have been applicable to them. The words are very, very categoric. Shall not be less favorable than those which would have been applicable to them if there had been no such transfer under the transfer scheme. So proviso is categoric. the terms and conditions shall not may not, shall not be less favorable than those which would have been applicable to them. So therefore, if I were an ASAB and a particular provision was applicable to me, it would remain applicable to me, notwithstanding the fact that I've been hived off to a company. That is our interpretation of section proviso. Lordship, now coming back to my submissions. Paragraph 4. Lordship has paragraph 4. Yeah. Lordship, this is our interpretation of this proviso. It is submitted section 133 is categoric in stipulating that the terms and conditions of transfer shall not be in any way less favorable than which would have been applicable had there been no transfer. Therefore, the mandate of the law is that the terms and conditions of service because of reorganization must not result in terms and conditions less favorable than what would have been had they remained in ASAB. So whatever would have been, in other words, what would have been applicable to ASAB employees would remain applicable to them even if they are now APDCL. That is the mandate of the proviso. It is submitted, therefore, the section of law is clear that upon reorganization, the erstwhile ASAB employees must not in any way be worse off than what would have been the situation had there been remained in ASAB. Now, Lordship, paragraph 5, ASAB employees from the beginning. ASAB was established in 1958. From the beginning, ASAB employees had a X+1, one increment more than the state government. And Lordship, we've pleaded that in paragraph 9. It has not been controverted in the opposition, in the affidavit in opposition. We've also pleaded that as per clause 5 of the tripartite agreement, as well as the mandate of the law, this pay structure has remained in force until 2021. So even after bifurcation, X+1 we have been receiving X+1 always. X+1 means we get one more increment than the state government employees. And that has been ASAB's pay structure from inception to the right now, which led us to come here, Lordship, 2017, the pay hike. Again, pleaded in paragraph 9 and not controverted. So it has not been controverted that we have been receiving X+1 from the beginning till now. It is submitted that the present petitioner enjoyed pay revision as was prevalent in ASAB, and that was agreed as well as required in law to be maintained even upon reorganization. Now, Lordship, what are the two impugned notifications? Lordship, I'll take you to the pages, page 43. What has prompted us to come here?
Page 43
43, yeah. It's there in paragraph 6, but I'll just take you to the
is impugned.
Lordship, impugned. We want this to be extended to us.
No, not impugned.
Not impugned, Your Lordship. Our prayer is please extend this to us. Lordship, what happens is the grade 3 cadre is the district is the lowest. On top of the district is the headquarter cadre. So by way of these two notifications, I'll show you one by one. They first revise the pay. And then they revise the pay of headquarters and then they merge it. So what typically happens is whatever the headquarter was getting, which is a higher cadre, in the state government, this is in the state government. What happens is this particular notification is applicable to the state government. So what happens now is the headquarter and the district quarter gets merged. So even though headquarter was a higher category, they both are getting the same thing. So our contention is, had we remained in ASAB, exactly this would have been applicable to us. And even for us, we would have gotten the pay hike. So Lordship, page 43 is the revision of pay. And Lordship, what's relevant for us is at page 45. Junior assistant is 6200. So Lordship, we are getting 5,800. Lordship, you find that at page 51, 52, what we are getting right now, pay structure, page 51. Lordship, all these pages are there in paragraph 5. Page 51, we are getting 58.
Where is that?
Page 52, Your Lordship. Serial number 5. 5800. Lordship has 1500.
Yes.
And now it has been increased to page 45, 6200.
45.
And this notification read with page 49. Which basically says the headquarter and the district is merged. Page 49. So our grievance basically has been that had we remained an ASAB, these two would have been applicable to us and our pay revision would have automatically been effected. And you are denying us this rise because we are an APDCL. And that is in breach of 133 and your transfer scheme, which says that anything that would have been applicable to us had we been ASAB should remain applicable to us as though we are always in ASAB. So, Lordship, that is what it is. Lordship, just a history, paragraph 8. I'll quickly read through these paragraphs, just the background. There was a meeting organized in 9/6/20 regarding merger of 3-tier system of the ministerial cadre into 1-tier system. However, the meeting failed to attain the desired result, and that is at page 56. Aggrieved by the non-implementation of August and September notification qua the petitioners, we moved the writ petition seeking directions to the that a direction may be issued to the committee constituted by APDSL to take a decision. This honorable call by way of order dated 20/10/20 directed the committee constituted by an office memorandum 5/1/2019 to conclude the proceeding and submit a report within 3 months. It is submitted as reflected in the office order. The composition of the committee was provided in the office memo 5/12/19. And this honorable court directed specifically to this committee as provided in the aforesaid office memo to submit a report. So this is our preliminary submission, that there was a mandamus to a particular committee, which is 5/1/2019, which had 9 members to give us a report. What we finally discovered, which is the impugned committee recommendation, which is at page 7 of the affidavit in opposition, Your Lordship. Lordship may come to that. It's affidavit in opposition. Running page, I think. No. Lordship, affidavit in opposition by respondent number 4, 5, 6, 8, 9, and 10.
Yes.
Lordship, internal page 7.
Yes.
Annexure A. Lordship has that. So, Lordship, this is the impugned recommendations. Our preliminary submission is that 5/1/2019, which is at page 55, Your Lordship, of my writ petition. If Lordship put side by side, page 7 and page 55, the composition is different.
Yes.
Yes. What my learned friend said is the composition by and large remains the same. They added few more. But our contention is, Lordship may kindly see page 64, which is the earlier order.
Page 64.
64.
Oh.
You have Lordship page 64. This is the first writ petition we filed asking for a direction that let the committee decide. In which Lordship paragraph 1 and 2 is basically our case. Paragraph 3. Lordship has paragraph 3. On grievance being raised, the chairman of APDCL by office order bearing dated 5/1/2019, which is Lordship page 55. I just showed you. Constitute a committee to suggest rationalization of service conditions and service rules of all cadres. The composition, Lordship, next page.
Yes.
Page 65, paragraph 4. The composition of the committee has also been provided in the said office memo, dated 5/1/2019, which is at page 55. The office order of 5/1/20 specifically provided that the committee would submit its report by 8/2/19. The petitioner enclosed the minutes of the meeting held on 9/6/20, and a reading of the minutes show that a committee has not arrived at any decision as regards the purpose for which it was constituted, meaning thereby to suggest rationalization. Then Lordship, paragraph 5, we have taken note of that the committee was constituted by office order 5/1/2019. So Lordship, this order goes on about 5/1/19, which is at page 55, and which had its own constitution to suggest rationalization of services, conditions and service rules of all cadre under APDCL. And the mandate was that the committee would submit a report by 8/2/2019. As it is discernible from the minutes of the meeting of the committee held on 9/6/20, the committee is yet to reach the stage of submitting the report as required by the order 5/1/19. In view of the mandate that the committee is required to submit a report by 8/2/19, we are of the view more than enough delay has already been caused and no reasons for such delay is discernible in the minutes of the meeting held so and so. Paragraph 7, Your Lordship. In view of the above, the writ petition stands disposed of by directing the committee constituted by the office order dated 5/1/19, which Lordship is at page 55, to conclude the proceedings and submit the report as required within a period of 3 months from the date of receipt of this order. So our preliminary submission, Your Lordship, is page 55 is the committee that was directed in page 65. Page 65, the mandamus is direct the committee constituted by office memorandum of 5/1/19. If they wanted to vary this, they're free to. They could add more. But Lordship, my submission is then they should have come to this court and sought leave to modify this mandamus and at least seek leave of the court to say, listen, this is not the committee we have right now. We want to add a few more. Lordship may give us permission. They don't do anything like that. We don't even know about it. We get to know on page 7 a committee that is constituted, which is different from page 55. So that is our preliminary submission. That they should have at least come to this Lordship. The mandamus was to a particular committee. They can't go behind the mandamus and constitute a committee as whatever they want. And if there is some predicament and they have some issues, they should have brought to the notice of the court and sought leave and got this committee constituted. That is the preliminary. Lordship, on merits now. Page 8 is observations and recommendations. Lordship has observations. Lordship, the second paragraph. First paragraph is just recording of what happened. As regards the demand of the petitioners under provision of section 133(2) of the Electricity Act 2003, that the terms and conditions of service should not be less favorable than the transfer scheme, the committee is of the view that section 133(2) is not applicable in the present case. That is our first point of grievance. The three cadre even existed prior to the unbundling of ASCB into separate companies, transmission and distribution. The terms and conditions of the service of the petitioners and their pay has never been less favorable than those which they had been receiving and enjoying prior to the unbundling. Lordship, impugned is this portion of the committee report. First impugned is, it is their finding and view that section 133 is not applicable. And why is section 133 not applicable? Because the terms and conditions of their service has never been less favorable than those which they had been receiving. So they froze it. If I have been receiving something as ASCB, and that is fine at that point of time, it's fine. Lordship, this is an erroneous, because 133 says, it doesn't say had. It says, Lordship, may kindly take a look at 133 again. Sorry, Your Lordship. Page 42. Page 42, Your Lordship. The wording is very, very provided that such terms and conditions on the transfer shall not in any way be less favorable than those which would have been applicable. So anything that would be applicable if I had remained in ASAB must remain applicable to me as though I remain in ASAB. So 133 mandate is that terms and conditions for me must be as though I always remained in ASAB. So if I was in ASAB, would these pay rise be applicable to me? Answer is yes, in which case, please extend this pay rise to us. That is our submission. Lordship, paragraph 10. I'll go back to my submission. Sorry, Your Lordship, my note is a little bit. Paragraph 10, Your Lordship. Apart from the preliminary submissions on merits, the committee erred in holding that section 133(2) is not at all applicable in the present case, and the terms and conditions of service and their pay has never been less favorable than those which they had been receiving, enjoying prior to the unbundling. I've quoted what the committee has had. Now, paragraph 11 is our submission. It is submitted firstly. Section 133(2) is a condition on the basis of which reorganization has taken place. And it is not a matter of discretion for an administrative body or an executive body concerned to apply or not to apply. Section 133(2) is the mandate of the law and is not subject to any policy decision of an administrative body, nor is it subject to any financial condition of the employer. It is in the form of a safeguard and assurance to all the employees before the reorganization that their terms and conditions will not be less favorable than what would have been applicable to them as ASAB employees had the reorganization not happened. The emphasis as stipulated in the statute is not that the terms and conditions will be less favorable than those that they had been receiving, but that they would not in any way be less favorable than those which would have been applicable to them if there had been no such transfer. In other words, had they remained in ASAB, whatever would be applicable to them would continue to remain applicable even if they're absorbed by the newly formed companies, and that because of the reorganization, they would not be at any time and in any way be worse off than what they would have got had they remained in ASAB. Paragraph 12, Lordship. And this is our submission. It is submitted that the Parliament, in its wisdom, chose not to leave it to the contracting parties to come to an agreement in this regard. Lordship, almost every restructuring of electricity board, it happened pan-India, Your Lordship. There was a transfer scheme. And I showed Your Lordship case, I extracted it. Kerala happened, Madhya Pradesh, my learned friend actually cited a case. Everywhere, there was a transfer scheme. But the Electricity Act chose to bring about 133 still. They didn't say, okay, two of the people get into an agreement and do it. They said no. Notwithstanding that, they enacted 133 to protect. So my submission is that the Parliament in its wisdom chose not to leave it to the contracting parties to come to an agreement in this regard. Instead, it stipulated this assurance in the form of a legislative mandate, leaving no room for discretion in its application and not subjecting it to employers' financial capacity. This issue it is submitted is decided by Supreme Court in so and so. Lordship, would you have the copy of this judgment in your, I had cited it. Extra copy, isn't it? Lordship, I've extracted the relevant. My note will be sufficient, I think. If your Lordship doesn't have it, we'll submit another one.
1 minute.
Yes, Your Lordship. It's 2022 SEC online.
Yes.
Yes, you have it. Lordship, I'll now not refer to it. I've extracted the relevant portion. Paragraph 13. Lordship, can I have a strepsil?
Yes.
Obliged, Your Lordship. Lordship has paragraph 13.
Yes.
The issue which is submitted has been decided by the Supreme Court in Muhammad AA versus State of Kerala. Citation is 22 SCC Online 198. The issue before the Supreme Court was whether Section 133 protected employees from treatment that would be prejudicial to them. And Lordship, it was interesting here. After the reorganization, there was an amendment in the regulation which required additional qualifications. The question was whether this regulation will be applicable to erstwhile employees. And the state of Kerala themselves realized that it should not be. So they amended the regulation to exempt the erstwhile employees. So the new employees challenged that deviation and said, sorry, how is it applicable to us and not to them? To which the court said, sorry, 133 protected them. So if at the time of erstwhile, this qualification was not required, you can't now, and it was in public interest. It was some new qualification which was in fire hazard, etc. Notwithstanding that, Section 133 trumped, Your Lordship, and said, sorry, if it was not applicable to the erstwhile, it can't now, it'll be applicable to the new people, whoever joins APDCL. But the erstwhile employees are protected by Section 133. Lordship, may I read?
Yes.
The issue before the Supreme Court was whether Section 133 protected employees from treatment that would be prejudicial to them. The question that arose for determination was whether Section 133(2) offered protection to employees who did not possess qualification required in terms of safety regulation. That was introduced after the reorganization. It was contended the non-application of the safety regulations would compromise the safety norms and adversely affect large public interest. I put the paragraph where this contention was there. The Honorable Supreme Court, rejecting this contention, held the erstwhile employees without the new qualifications are protected by the proviso to Section 133(2). It provided, Part 8 of Electricity Act pertains to reorganization of KSAB. According to the Statement of Objects and Regions of Electricity Act, one of the features of the Electricity Bill 2001 relates to the incorporation of a transfer scheme by which companies can be created by the state government. The state governments were given, this is the history actually, given the option of continuing with the State Electricity Board, which under the new scheme of things would be a distribution licensee and a transmission utility, which would also be owning generation assets. It provided that the service conditions of the employees would, as a result of restructuring, not be inferior. Then Lordship, paragraph 18. Reorganization of the Electricity Board has been done in terms of the Electricity Act by preparation of a transfer scheme, as contemplated in Section 131 of the Act. According to Section 133(2) of the Electricity Act, the transferred personnel have to be governed by terms and conditions as may be determined in accordance with the transfer scheme. The proviso to Section 133(2) protects the interests of the transferees insofar as the conditions of their services are not to be less favorable than those which would have been applicable to them had no transfer taken place. The parties entered into such a tripartite agreement in which it was agreed that promotion of the existing employees would continue to be governed by existing regulations and rules in vogue. It is clear from the above discussion that the service conditions of the erstwhile employees of KSEB are protected by the proviso to Section 133 of the Electricity Act. After the transfer scheme was formulated, the erstwhile employees were entitled to claim that the conditions of their service cannot be altered to their detriment in view of the tripartite agreement. Lordship, then I'm grateful to my learned friend. He relies on a case which actually squarely supports us. And he considered that. Similarly, it was held, Honorable High Court, Madhya Pradesh, and MP Vidyut Mandal, a case cited by the respondent. Lordship has that case, I can Madhya Pradesh.
Have you furnished a copy?
Lordship,
Yes, I believe perhaps it will be in Lordship report.
I have an extra copy.
Party of British, I don't know. Vidyut Mandan.
Yes, Your Lordship.
Ah, I have.
Similarly, it was held by the Honorable High Court of Madhya Pradesh in so and so that change in service conditions of employees, Lordship has paragraph 14. Yeah. Change in service conditions of employees of erstwhile board is not permissible, and promotion of such employees would be governed by the terms of the rules as amended by the board, erstwhile board. The Honorable High Court held a perusal of section 133 of 2003 Act will make it clear that again service conditions of the employees and officers of the erstwhile board are protected, and at least no such new conditions were to be made detriment to their interest. It went on to say, thus, there is no hesitation in holding that amendment would not be made in such service conditions which were available to petitioners on account of their transfer and absorption in a newly formed companies. The change of service condition is not permissible in terms of the statutory provisions of 2000 and 2003 Act. Of course, new conditions can be leveled, but the same would be applicable to new entrants who are inducted into service of the companies after coming into force the new rules. So, Lordship, it is Supreme Court, High Court, and the stated rule that section 133 is an assurance to erstwhile employees that terms and conditions will not change and will remain as though they always remained in ASCB. So our contention is those notifications, if we had been in ASCB, would have been extended to us. And we would have been a beneficiary of a pay hike, which they have actually done that till 2017. Suddenly they now wake up and say no. You know, Lordship, to be fair to learned friend, he argued proposition of law we agreed on. He in fact agreed and said that yes, if it was applicable, and there were only a difference he made was that we were getting paid, he said. His words were may. He said, we may have been getting X plus, but we are not entitled. And the reason why we are not entitled, Your Lordship, is because he could not trace any notification entitling us. The question that arises is, a state ASCB organ, Article 12, taxpayers' money, from 1958, if you have been paying, it's unbecoming of the state to suddenly come and say, we've been paying, but you're not entitled. How does the state pay taxpayers' money as a bounty? So, Lordship, that argument has to be stated only to be rejected. We were getting paid because we are entitled. And for 50 years, the state will not give us a bounty. So, Lordship, paragraph 15. The pleaded case and the argued case, Lordship, it is my submission is different. And I've quoted it. It is submitted that the respondents argued differently from their pleaded case. Lordship, this is what they pleaded, paragraph 6 of the affidavit in opposition. I've quoted verbatim. It was pleaded that APDCL, being a public limited company, any decision regarding implementation or adoption of any decision or scheme of the state government is entirely at the discretion of the board of directors. Lordship, this is in the teeth of section 133. Further, the petitioners claim that there is a violation of principle of equal pay for equal work as a result of non-implementation of the government notification is without any basis in law. Lordship, this is important. As they, being regular employees of APDCL, are subject to their own service rules and hence cannot be compared to employees of the state government. So their pleaded case is in the teeth of section 133. Their pleaded case is, sorry, you may have been getting whatever you're getting in ASCB. After you became APDCL, you are APDCL and you are subjected to APDCL rules and regulations, which basically wipes out section 133 proviso assurance, which says that, sorry, even if you've been hived off, you'll remain, your terms and conditions will remain as though. And Lordship has seen two cases where in interest of safety also they don't make it applicable. Because what was then and what would have been applicable to you as a state government, not as a new company. It is submitted, this pleaded case is contrary to the mandate of law in section 133(2), whose applicability is not a subject matter of discretion, and the tripartite agreement that the terms and conditions will not be inferior and cannot be altered to their detriment. As against this pleaded case, it was however accepted during arguments that it is common ground that proviso to section 133(2) protects the interests of the transferee such that the conditions of service will not be less favorable than those which would have been applicable to them had they not been transferred. Instead, the respondent argues the petitioners are not entitled to receive the same pay as the state government employees. Respondents even accepts that they may be receiving the same plus increment, but because they could not retrieve any notification entitling the same pay plus increment, it is now the respondent's discretion to whether or not continue with the same pay grade. The petitioner submits the applicability of the mandate of the law is not dependent on the respondent's ability to retrieve a notification. ASCB employees from the beginning, its establishment 1958, had a pay structure that was one increment more than that of state government. This pay structure, in fact, remained that way all throughout till 2017. Lordship, we are not just saying it off the cuff. It's pleaded and not controverted. And to be fair to my learned friend, he said we may be getting it. It is therefore incomprehensible that the respondent, which is an erstwhile state board, an organ of the state, to contend that what was paid consistently for more than 50 years was a bounty and not an entitlement. Such an argument must only be stated to be rejected. A pay structure of 1 plus increment more than the state government was the pay regime in erstwhile ASCB. And it was the terms of service operating over 50 years until reorganization. And it was this pay regime that was promised by way of the tripartite agreement as well as the mandate of the law to be continued even after reorganization. Discontinuation of this pay structure inevitably will result in terms and conditions that will be inferior and an alteration that will be detrimental to the employees. It is submitted, this is in the teeth of 133(2), and our prayer is therefore that the 2 notification pay hike should be extended to us. That is our submission.
Firstly, there is no quarrel with the proposition that as per section 133 of the Act, their conditions of service cannot be changed to their detrimental. You cannot do it. The Act does not permit us to do it. Now, the question is, Your Lordship, what would constitute a condition of service? The mere fact that the board, erstwhile board, on certain occasions had fixed their pay at a scale which was X plus 1 compared to the state government. Would it be a condition of service? Can they say that because it was a practice that was followed, will that become a vested right in their favor that in perpetuity we'll have to get what plus 1 increment with the government of Assam, what the employees of the government of Assam are getting? In my submission, that cannot be a condition of service, Your Lordship. And if that is not a condition of service, perhaps any decision taken by the successor company of ASCB, APDCL, not to extend it benefit, Your Lordship, would not be a violation of section 130. Now, the prayers, Your Lordship, are primarily twofold in this petition. Their first prayer, Your Lordship, is that the 3 cadres, that is the chairman cadre, that is the headquarter cadre, the head of department cadre, and the district cadre should be merged into one single cadre. Now, since those cadres existed prior to the unbundling of the ASCB, so that would definitely not be a change in the service conditions, because that condition existed even prior to the unbundling of the ASCB into the 3 successor companies. Now, regarding their claim for a hike in their pay, Your Lordship, because of the pay revision granted to government employees of the government of Assam. Now, if I may take Your Lordship to what the committee, Your Lordship, held in its meeting, Your Lordship, what the finding was. At page number 8 of the affidavit in opposition.
Yes.
These are the 5 observations and recommendations of the committee. The second paragraph. As regards the demand of the petitioners under I'm reading from the observations and recommendation. As regards the demand of the petitioners, under provision of section 133(2) of the Electricity Act, that the terms and conditions would not be less favorable under the transfer scheme, the committee is of the view that section 133(2) is not at all applicable in the present case. The three cadres even existed prior to unbundling of ACB into separate companies for generation, transmission, and distribution. The terms and conditions of the service of the petitioners and their pay has never been less favorable than those which they had been enjoying prior to unbundling. Now, this is their view as far as the demand regarding merger of the cadres is involved. Now, regarding the pay hike, Your Lordship, that finding Your Lordship will have at the next page, at page number 9.
Yes.
Further, there will be approximate, I'm reading the the third paragraph. Further, there will be an approximate financial involvement of rupees 2 crores per annum if the merger happens and the promotional avenues are enhanced in accordance with the headquarter cadre. Considering the stress financial condition of APDCL, with accumulated losses, the merger of the three cadres would not be feasible. Now, Your Lordship, the question I ask myself is that the judgments produced by the petitioners, Your Lordship, in both in the Madhya Pradesh High Court judgment as well as the Supreme Court judgment, the conditions of service have been changed. In one, some safety qualifications have been introduced, and in the other, the qualifications, the basic qualifications has been changed. But here, Your Lordship, what they want is, they themselves want the present conditions of service to be changed. So, on the last occasion, Your Lordship, I had made a submission that though as a matter of practice, they might have been getting one increment more than the government of Assam, they did not have a vested right to get it, Your Lordship. So, I have these service rules which govern their services, Your Lordship. What is it? This is the
Yes.
these rules are called the Assam State Electricity General Service Regulations of 1960. That if Your Lordship, if I may have Your Lordship's attention at page number 2, Your Lordship. Page number 1, the name of the rules are there. This is applicable to all employees of the erstwhile ACB. It was applicable. And at page number 2, at the bottom of the page, regulation 1K, pay has been defined. Pay means the amount drawn monthly or otherwise by an employee as remuneration fixed in relation to the post held by him, and includes personal pay, special pay, and other emoluments which may be specifically classed as pay by the board. Now, at page number 215, Your Lordship, the entitlement has been laid down.
Yes.
The chapter is chapter 9, pay and increments. Pay. The pay applicable to different categories of services under the board shall be as fixed by the board from time to time. So merely because the pay and allowances of the government of employees of the government of Assam have been enhanced, that would not confer a right on the employees of the erstwhile ACB to claim that they would also have to be given that scale or one scale more than that, Your Lordship, unless the board fixed it, Your Lordship. So their service condition said that they would be entitled to such pay as fixed by the board. So as a matter of practice, they might have been getting X plus 1, or it might be X minus 1 also, but that would not confer them any right to say that we have to continue to get it in perpetuity. And unless they have such a right, Your Lordship, it cannot be said that the conditions of service have been violated. So in this regard, Your Lordship, I'd like to rely on one judgment of the Honorable Apex Court. Perhaps that judgment is already there, Your Lordship.
Give the citation.
It is already there. 2003 9 SEC 592. STA Naqshbandi and others versus. Perhaps 2003 9 SEC 592, paragraph number 8. It is I have a copy, Lordship. This is the copy.
Okay.
Here, the question was regarding grant of special time scale to certain members of the Jammu and Kashmir Judicial Services. And there, the Honorable Apex Court, Your Lordship, was one of the aspects which was considered is what would constitute conditions of service, Your Lordship, and how would those conditions be governed. If I may take Your Lordship to paragraph number 8, Your Lordship. This is the relevant portion, paragraph number 8.
Yes.
Reliance placed upon the recommendations of Justice so-and-so Commission or the decision reported in All India Judges Association versus Union of India, or even the resolution of the full court of the High Court dated 27/4/2002 is not only inappropriate but a misplaced one, and the grievances espoused based on this assumption deserve a mere mention only to be rejected. The conditions of service of members of any service for that matter are governed by statutory rules. The conditions of service of members of any service for that matter are governed by statutory rules and orders lawfully made in the absence of rules to cover the area which has not been specifically covered by such rules. And so long as they are not replaced or amended in the manner known to law, it would be futile for anyone to claim for those existing rules stroke orders being ignored, yielding place to certain policy decisions taken, even to alter, amend, or modify them. So, Your Lordship, the right which is vested in favor of the petitioners and all other employees of the erstwhile ACB is that their pay would be as fixed by the board. Now, on some occasions, the board may have fixed it on an increment more than that being allowed to employees of the government of Assam. But that would not be the condition of their service. Their condition of service is to get pay as fixed. And at present, the financial condition of the APDCL is such that we cannot grant them that benefit. So they cannot say that their conditions of service have been affected. They are getting pay as per the rules and as fixed by APDCL, Lordship, as is financially viable for us, Your Lordship. In this regard, Your Lordship, I would like to rely upon another judgment of the Honorable Apex Court. Okay. This is 2003 5 SCC 163. 2003 5 SCC 163. Here the issue was, Your Lordship, if the main issue was if the state government, Your Lordship, can be the issue before the Apex Court in that matter was that the petitioners were claiming that the benefit, though they were from a government company, that the financial burden to give them that benefit should be borne by the state government. That was the principal claim. But some of the observations of the Apex Court, Your Lordship, would be relevant. Let me take Your Lordship to paragraph number 17, Your Lordship. 17, 18, and 19 are the relevant paragraph. The legal position is that identity of the government company remains distinct from the government. The government company is not identified with the union but has been placed under a special system of control and conferred special privileges by virtue of the provisions contained in section 619 and 20 of the Companies Act. Merely because the entire shareholding is owned by the central government will not make the incorporated company as central government. It is also well settled that the employees of the government company are not civil servants and so are not entitled to the protections afforded by Article 311 of the Constitution. Since employees of government companies are not government servants, they have absolutely no legal right to claim that the government should pay their salary or that the additional expenditure incurred on account of revision of their pay scale should be met by the government. Being employees of the companies, it is the responsibility of the companies to pay them salary. And if the company is sustaining losses continuously over a period and does not have the financial capacity to revise or enhance the pay scale, the petitioners cannot claim any legal right to ask for a direction to the central government to meet the additional expenditures which may be incurred on account of revision of pay scales. Right. Then the next, it is a narration and facts in paragraph number 18, Your Lordship. We are unable to accept the contention of so-and-so that on account of non-revision of pay scales of the petitioners in the year 1992, there has been any violation of their fundamental rights guaranteed under Article 21 of the Constitution. Article 21 provides that no person shall be deprived of his life or personal liberty except according to procedure established by law. The scope and content of this article has been expanded by judicial decisions. Right to life enshrined in this article means something more than survival or animal existence. It will include the right to live with human dignity. Payment of a very small subsistence allowance to an employee under suspension, which would be wholly insufficient to sustain his living, was held to be violative of Article 21 of the Constitution in state of Maharashtra versus Chandrabhan Tale. Similarly, unfair conditions of labor in so and so, it has been held to embrace within its field the right to livelihood by means which are not illegal, immoral, or opposed to public policy in Olga Tales versus Bombay Municipal Corporation. But to hold that mere non-revision of pay scale would also amount to violation of the fundamental right guaranteed under Article 21, would be stretching it too far and cannot be countenanced. Next, paragraph number 19, Your Lordship. The contention of economic viability of the industrial unit or the financial capacity of the employer cannot be taken into consideration in the matter of revision of pay scale of the employees does not appeal to us. So it is one of the principal considerations, Your Lordship, whenever a prayer is made for revision of pay scales. Now, in this particular matter, once it has been determined that their only right is to get the pay as fixed by the board, and their conditions of service did not allow them to get their pay at one scale more than what the government of employees of the government of Assam were getting, they cannot now say that regardless of whatever the financial condition of APDCL is, we have to be granted that pay in perpetuity. That cannot be because that would make the entire enterprise unsustainable, you know. Because the joint committee has said, Your Lordship, has come to a categorical finding that the burden, Your Lordship, of merger and enhancement is such that we would not be able to bear it. And as far as section 133 is there, we do not have any quorum. In fact, they are presently the ones who want those conditions to be changed, because today they are before Your Lordship saying that it should be merged into one cadre. Now, if there was somebody who is happy with that situation, that's saying that, yes, I was happy with the cadres being separate, merger of the three cadres into one cadre, Your Lordship, will be in the teeth of their rights guaranteed under 133. Because that has continued. And it was the system even when the ACB was there. So my submission is that because, and there was a preliminary objection raised, Your Lordship, that the constitution of the committee was different from what was originally there. The minutes, Your Lordship, would reflect that all the members who were there in the original order of 5th of February, all of them were present, but they had co-opted, Your Lordship, the services of some additional officers to allow them to come to a decision. At the end of the day, Your Lordship, that decision has been taken by the committee constituted for that purpose. So perhaps on that technical ground, it may not call for any interpretation. That is my
Which argument?
Your Lordship.
Yes.
Should I just quickly? I'm going to again rely on the judgment that my learned friend is this thing. Terms and condition of is as per statute and as per orders. So what I fail to understand now is, if that be so, can the state board first 50 years and then APDCL, a public company, be paying X+1 dehors of statute and dehors of orders? Are they admitting that they have been paying just as a bounty? Are they then admitting that for the last 50 years, what the state board has fixed and what APDSL is paying in 2016 is contrary to statute, contrary to orders, and is a bounty, that's a scam, Your Lordship. How can you pay taxpayers? How can any state or any public company pay monies over a period of 50 years without actually their being entitled to it? And otherwise, it's a scam, Your Lordship. Are they admitting that's a scam? They have not controverted. We have been paying X plus. What is the moot thing here? Every argument that my learned friend is making is an argument that was anticipated and an assurance granted under Section 133(2). That is why the State Electricity Supply Act 2003 didn't leave it to contracting parties to agree. They said, sorry, we will mandate it. If the state board, because of its financial difficulty was absolutely imminent on them. So if they wanted to add a caveat of financial, why did reorganization happen? Because of financial difficulty. So that was looming large. If they wanted Section 133 proviso to be subject to financial, which they were very aware of, they would have done so. It is anticipating the company coming back and saying, sorry, we will not have money to pay, is why the protection of 133(2) is granted. And the second case, that is not a Section 133(2) case. I want to see, in the face of protection of 133(2) and in the facts and circumstances of an electricity board saying, okay, fine, we will allow reorganization. But the condition is, and I read out, Your Lordship, the preamble. There was apprehension that our terms and conditions will be affected, to which the state board said no. The state board at that point of time, learned friend points out, had the right to fix. So 133 assurance is that even if we are not there, you will be protected as though we are there. So the moot question is those two notifications, which increases the pay. Question is, if reorganization had not happened and I remained an ASCB, would they have been applicable to me or not? If my learned friend gets up and on affidavit says no, that's
I can
fine.
say it
That's
right now, unless it is fixed by the board, it would not be applicable. That will be recorded.
the board, because that is the point. That is the point
That's
I'm
recorded.
making. That
Can
is
be
the point
recorded.
I'm making. That is the assurance of 133(2). I'm grateful. I'm very grateful to my learned friend.
Can be recorded. It specifically says that unless it is fixed, that
Rightly. So the assurance was
in the realm
given
of
is that
hypothesis that it will be fixed. It cannot be, may not have been fixed.
that is the assurance. Lordship, that is 133(2). That is why 133(2) was brought in, saying that I will not be there. The board will not be there to fix. But your terms and conditions will remain as though I was there and I was fixing your board pay case scale. And that is the protection of 133(2). And that is not the same as any other pay scale revision, any other entitlement. A state board reorganizing into a private company, when they did, the statute was brought into being and was mandated that you will always be treated as though you belong to the board. And your terms and conditions will be such as though you were part of the board. And as though the board had the power to fix. And there is no subject to financial conditions. So this is actually reneging on terms and conditions and against the mandate of the law. That is my submission. My submission is that according to 133(2), the two notifications, if I were an ASCB, it would have been applicable and therefore it must be made applicable to me. Yes, Your Lordship, I had extracted it in the terms of the scheme. All benefits of services rendered by the employees in the board as on the date of restructuring shall be protected and shall be given full effect to. So, Lordship, my submission is every argument that my learned friend. Lordship, it's there in my submission, Your Lordship. No, don't. One second. Lordship, page 2 of my submission. Paragraph 2, I've extracted, Your Lordship. It's at page 27. At page 30. Lordship, I read out.
Yes, it is there. Page number 2.
This clause is there in my written submission, Your Lordship. You want to see the clause, Lordship, at page 30 then?
It says that any change of existing service conditions such as seniority, promotion, transfer, leave, pay, allowances, etc. shall be regulated by the existing service rules regulations in vogue at the bottom of the page. Your Honor. Clause 5C.
Close.
Clause 5C of that agreement which my learned friend is referring to. Page number, if your lordship has page number 28 of the petition,
Yes.
5C is at the bottom of the page. The terms and service conditions upon transfer to the successor entities shall not be in any way less favorable than the present terms and conditions under the AACB. In fact, the endeavor would be to rationalize the terms and conditions to provide for reasonable career growth and other welfare measures more beneficial to employees, recognizing that the employees are an essential part of the growth of the power sector and in operation in an economic and efficient manner. Any change of existing service conditions such as seniority, promotion, transfer, leave, pay allowances, etc. shall be regulated by the existing service rules stroke regulations in vogue unless it is modified by mutual consultations and mutual agreement. So these are the regulations which were in vogue then. Your Lord.
Lordship, there's also J, the next page, 32. I've extracted this because I rely heavily on it. And J, one more clause.
Yeah.
All benefits of service rendered by employees in the board as on date of restructuring shall be protected and shall be given full effect to. So in effect, what was in vogue was what ASCB, the board was fixing. So what was in vogue was ASCB fixing. So therefore, 133 said that you will remain as though you were in ASCB. That is the bottom line.
Okay.
Lordship, should I rejoin to this note? May I be given liberty 1 week? Because we've not read these cases. If you would like to distinguish.
You want to take some time?
No, I'll just submit it, Your Lordship. No, we'll just tender it. If you give us next Friday, we'll just,
Next Friday is a holiday.
if Lordship, we'll give it, we'll file it in the meantime. Lordship doesn't have to list the matter for it. Unless Lordship is dictating the order sooner than that. As Your Lordship pleases. Because we've not seen it, so I don't want.
Can you give by Monday?
Okay, Monday,
Okay,
Monday.
fine.
Yeah.
Okay, heard MS G Goswami, learned also petitioner. Also heard Mr.
AP part.
KP Bathak, learned standing counsel, ABTCL. Stop. Heard in part, list for further hearing on. This is not for hearing, but just.
Just a tender, yeah.
just
Lordship,
tender.
we can even file it if Your Lordship.
Anyway, let it
Yeah,
come
okay.
after that, I'll reserve it.
Okay. Oblige, Your Lordship.
You can make a mention on fourth so that it can be upgraded with you. This is just for filing. Okay, okay.
Okay,
Okay.
we'll mention it. Oblige, Your Lordship.
17.
May I please, my lord? My lord, conducting counsel, my lord, Digo is in needs of a hearing in court number 1. My lord. Perhaps may I take it after some time, my lord.
I may just recapitulate by the time he arrives. If your
It
lordship.
will take some
thinks so.
time, my lord.
Okay, let him come after some time.
I'm deeply aware.
18.
My lord, I am for the respondent in this case, and the petitioner filed one IA.
You are the respondent.
I am for the respondent. No, sorry, my lord, I am for the petitioner.
Oh,
The
yes.
respondent has filed the IA.
SK Methi, CGC Council.
What is it?
CGC Council, Mr. SK Methi.
Yes.
Lordship,
What do you want?
Lordship, allow us to filing.
They filed an IA, my lord. There was some mistake in filing the affidavit in a position. Wrongly they filed the relating to the other case. So that is why they have filed this IA for
Okay, where's
rectification.
Mehdi?
Next, another one. I call it.
What is this IA? He wants to withdraw the affidavit in opposition.
They filed the affidavit in opposition wrongly. They are saying wrongly it was filed relating to the other case. So they want to withdraw.
Do you have any objection?
No objection because they want to file another, by mistake they have filed.
Yes,
Lordship, he is coming.
he's coming. Next case is also Medi's case.
Yes, my lord. He is
Your-
appealing.
Your matter.
Yes.
Is it ready?
I am ready, my lord.
Both cases.
In this case, my lord, they want to file the another affidavit in opposition. And in other case, they have already filed the affidavit in opposition. So I am ready for next case.
Yes, Medi.
Well, this IAS file for withdraw the earlier affidavit in opposition.
Mm.
Well, there's two cases, my lord. Item 19 and 18, my lord.
Mm.
Well, mistakenly we filed this this affidavit in that case. Party is same, my lord. And it was already withdrawn, my lord. Now this is filed by withdrawn the affidavit of the present case file.
Arbitration 14.
Yes, my lord.
You want to withdraw the affidavit in opposition.
My lord, the affidavit in opposition and to file and then this one. my lord.
Okay, in the I heard Mr. S.K. Medi, Leonard CGC for the applicants. Also heard Mr.
R. Hussain.
R. Hussain, Leonard Counsel for the opposite party, sole opposite party. Stop. By this application, the applicant oblique Union of India is praying for withdrawal of the affidavit in opposition
Filed on 11/8/2022.
filed on 11/8/2022 in our petition number 14/2022. So, para. This court has considered the question at para 2 of the present applicant. So, and accordingly, the prayer for withdrawal of the affidavit in opposition filed on 11/8/2022 is allowed. Stop. Is disposed in the amended petition. In view of the order passed to them, so and so. The respondents are allowed to withdraw the affidavit filed on 11/8/2022. Stop. Heard Mr. R. Hussain, Leonard Counsel for the petitioner. Mr. S.K. Medi, Leonard CGC is allowed. How much time you want?
My lord, at least my lord, 3 weeks time, my lord.
Allowed 3 weeks time to file a fresh affidavit in opposition. Least after 3 weeks.
I don't know, 19 also, I'm not prepared now today. I'm not make after 3 weeks.
No, my lord, let it come after next week.
Next week, my lord, there's next week and 7, my lord.
7 will be difficult.
My lord, next week, my lord, on 4 also, my lord, 4 Monday, my lord.
And then let us not take up next week, the week after that.
And then, that week I'm
Then
not
thereafter,
available here.
yes, thereafter any date may be picked one.
From 11 my lord to 16, I'm not available.
11 to 16, you're not available.
Yeah.
Then we'll file it, we'll list it after that. Heard Mr. R. Hussain and the counsel for the petitioner on request made by Mr. S.K. Medi. Then it's CGC, list down. When do you want? 21st?
21st, my lord, and 19, 27, my lord.
27.
27, there will be some difficulties.
18, my lord, 18.
19 only, 19.
19. Yes.
20,
Wait, please, just Well, issue involved in this writ petition is regarding the age of superannuation. What will be the age of superannuation of the petitioner? It will be 60 years or it will be 65 years? That is the issues to be decided by your lordship.
Yes.
My lord, the petitioner is a professor under Amiyo Kumar Das Institute of Social Change and Development. The Amiyo Kumar Das Institute
Huh?
is an institute which was established.
Is a, you are professor
I'm professor, my lord.
in which college?
Not in Amiyo Kumar Das Institute of Social Change and Development.
Okay.
Well, the Amiyo Kumar Das Institute was established by the state government as well as ICSSR, which comes under the Ministry of Education, Central Government, Union of India. It's a joint undertaking of the state government as well as ICSSR. And my lord, the petitioner, lordship comes to page my lord, 7. By this notification of 31st of October 1998, petitioner was appointed as my lord, in pursuance of the decision of the governing body in its meeting held on so-and-so, Dr. Bhupen Sharma, lecturer, political science, Center for Himalayan Studies, North Bengal University, is appointed a reader in the institute in the UGC approved pay scale. He will be on probation for a period of 1 year, so-and-so. But according in pursuance of that, my lord, the petitioner joined in service. And if your lordship turns to the next page, that is page 68. Lordship will find a notification which was issued on February 14, 2007. The petitioner, in pursuance of the approval of the 34th meeting of the governing body of the institute held on so-and-so, Dr. Bhupen Sharma is promoted to the grade of professor under career advancement scheme of the institute in the UGC scale of pay, plus other admissible allowances from time to time, as when he attained the qualification for promotion under CAS. Subsequently, my lord, on the next page, a post of professor, regular professor, all vacant. Petitioner applied and he was appointed as professor under that scheme accordingly, my lord. Page 67. In pursuance of the resolution of the 46th meeting of the governing body of Amiyo Kumar Das Institute of Social Change and Development held on so-and-so, Dr. Bhupen Sharma is appointed as a professor at the institute with immediate effect in the UGC scale of pay of rupees so-and-so, with admissible allowances as per institute's rules. Dr. Sharma was already a professor under Careers Advancement Scheme. His salary will be protected. He is to join the position with immediate effect. My lord, petitioner, after that, my lord, since till that petitioner is working as professor in the institute. And in fact, my lord, from time to time, various resolutions has been taken by the governing body of the institute, some of which your lordship will find.
One minute. Yes.
If your lordship turns to page 70, this is the minutes of the governing body of the institute. It was held on 14th of December 1999. And if your lordship turns to page 72, under agenda item number 4,
Yes.
Lordship, the institute adopted the UGC notification 1998 for faculty and Assam Gazette notification for non-academic staff. The governing body accepted UGC notification on revision of pay scale, minimum qualification for appointment of teachers in universities and colleges, and other measures for maintenance of standard 1998 for faculty of the institute. It has also adopted Assam Gazette notification that is for, my lord, non-academic staff. And my lord, Lordship may kindly turn to page 78, my lord. And in the meantime, what happened, my lord, the cabinet, a decision was taken by the government of Assam. The cabinet, as per the cabinet, the age of superannuation of professors of educational institutes has been increased to 65 years. And in pursuance of that cabinet decision, my lord, a notification was issued by the Higher Education Department, which your lordship will find at page 78. Lordship has got it, my lord. Page 78. Subject implementation of COF decision taken by the cabinet in its meeting held on 19/9/2012, raising retirement age. I am directed to convey government's decision taken in the cabinet meeting held on 19/9/2012 as stated below for taking necessary action at your end. It was decided to raise the retirement of all professors of educational institutions, including medical colleges, to 65 years.
Yes.
On the basis of this notification, my lord, all the professors of universities has been increased to 65 years. Now that benefit of enhancement of superannuation to 65 years has been denied to the petitioner and to the professors of the institute, my lord.
Of this institute.
Yes, my lord. And the institute
On
on
what
various occasions has taken repeated resolutions raising regarding the age of superannuation. Repeated request has also been made to the state government that it should be as per with that of the cabinet decision. Lordship may kindly turn to page 79, my lord. Now, this is the minutes of 52nd meeting of the governing body, which was held on 22nd of August 2014. Lordship may kindly come to page 83 for a moment.
Yes.
At agenda 4.8, Lordship has got it, my lord.
Yes.
Retirement age of faculty and non-faculty staff of the institute. The director reported that the 30th meeting of the governing body held on May 25th, 2005 noted agenda item number 6 that while the institute has adopted UGC scale of pay for faculty members, no decision has been taken by the governing body. But the second paragraph is important, my lord. The resolution of the 30th meeting of the governing body held on May 25, 2005, however, does not specify service conditions, including age of retirement of both faculty and non-faculty employees of the institute. The ministry filed its letter number so-and-so, dated November 30, 2010. That I will place your lordship after some time, my lord. While according sanction to 6 CPC to the employees of the institute, mentions clearly that service conditions of employees should be identical to those state central government employees. My whole case of the petitioner in this petition is that the conditions of service of the petitioner in this institute should be as per the respective state university.
In this minister's letter.
That your lordship will find that page 455. That additional affidavit is there, my lord.
Additional affidavit.
Reply affidavit. There is a separate affidavit file, I think.
Affidavit in opposition. Then-
Page 455, my lord.
How many affidavits have been filed?
There are 9, my
We
lord,
have
replies.
filed 2 affidavits. He also filed 2. 450,
5, my lord.
yes.
That is the same communication reference of which was mentioned in page 83, my lord. This was issued by the member secretary to the member secretary from the Ministry of Human Resource Development, Department of Higher Education. On 30th of November 2010.
Mm.
Regarding revision of pay scales of employees of research institutes by Indian Council of Social Science Research, ICSSR. This institute, my lord, where the petitioner is working, is under direct control of the state government as well as ICSSR. Lordship may skip the other parts, my lord. The relevant part, the Lordship will find at page 457.
Mm.
Clause F.
Yes.
The pay scale and allowances of the academic posts, qualifications, recruitment rules, etc. should be as per UGC norms or state university norms.
No, not this. Should be some-
Academic post, Lordship has got it.
Mm.
The pay scales, allowances of the academic posts. It is an academic post, my lord, professor. Qualifications, recruitment rules, etc. should be as per UGC norms or state university norms.
Yes, yeah.
In fact, my lord, there are 24 research institutes which are funded by ICSSR and respective state governments in the country. Out of which there are 4 institutes which are 100% funded by ICSSR, where the age of superannuation of all professors is 65 years. And in respect of the other institutes that are also on record, my lords, Lordship may kindly turn to page 459, the same document, my lord.
Hmm.
This was a communication issued by the institute to the state government. With reference to the letter on the subject cited above, I am enclosing herewith age of retirement of all 24 research institutes under ICSSR and respective state governments. Here, my lord, the case of the petitioner is that whatever is applicable in the respective state university, the age of superannuation should be the same to the institute also. If your lordship sees the next page, 460, now there is an Institute of Social and Economic Change. It is in Karnataka. The age of superannuation of professor is 62 years in the respective state universities as well as in the respective institutes which are funded and under the control of ICSSR and rather state of Karnataka, my lord. Similarly, my lord, as for example, in West Bengal, it is 62 years. In serial number 4, in Bihar, all professors in the state universities, they retire at 65 years and professor of the institute also retires at 65 years. But if your lordship comes to 462, serial number 24, Omiya Kumar Das Institute, here professors retired at 60 years. But the professors in the respective state universities, they retire at 65 years. That precisely is the discrimination petitioner is urging for your lordship, that since it is as per respective state universities, it should be made applicable to the petitioner also. Since universities has already acted upon and enhanced the age of superannuation of professors to 65 years. Lordship, that proposition was first, my lord, rejected by the state government, my lord, in the year 2014. Lordship will page 85, my lord. In fact, prior to that, many requests has been made to the state government for enhancement of age of superannuation. Lordship may kindly turn to page 85 for a moment. This was issued on 20th December 2014 to the director, Omiya Kumar Das Institute of Social Change and Development, so and so. In inviting reference to your letter cited above, this is to inform you that after careful consideration of your proposal and resolutions of the 52nd meeting of the governing body, well, in 52 board meeting, a resolution was taken by the board. That is a part of this record, the repetition, that the age of superannuation of professors should be to that of 65 years. At 52 board meeting, lordship will find page 79, lordship, I have already shown to your lordship.
Yes.
At page 83, relevant portion, my lord. And the resolution is at page 84. May I read, my lord? The service conditions including age of superannuation for faculty members of the institute shall be as per rules and regulations laid down by the UGC Grants Commission. Further, the service conditions including the age of superannuation of the other staff of the institute as per the rules and regulations laid down by the Government of India for the central government employees. So UGC directly is not applicable to the institute, admittedly, my lord. But since UGC has prescribed that the age of superannuation should be of professors should be 65 years, and in pursuance to that, the cabinet has already taken a decision in increasing the age of superannuation to 65 years. The board has taken this decision. This, my lord, by this communication at page 85, the state government rejected this proposal, my lord. At clause 2, my lord, the matter relating to retirement age of faculty members and other staff of the institute has been considered in detail. After careful consideration of retirement age of employees of Government of Assam, the other institutes established by Government of Assam, UGC circulars, Supreme Court verdict, etc. on the subject, it is felt that retirement of both faculty and other staff of the institute should remain at 60 years of age. Interestingly, my lord, if your lordship turns the next page, the same communication, lordship will kindly come to 3C. Well, it has a bearing, my lord, therefore I am referring to this. Finally, the post of professor and other faculty members would be advertised more broadly so as to pool of selection is wider by inclusion of appropriate national journals, newspapers. These views may put up for the governing body. The government wants to say that you advertise in a broader way so that it attracts people to the institute as a professor. But they are at the same time, they are not increasing the age of superannuation. If, my lord, the age of superannuation remains at 60 years, no person from any other university system will come to this institute to lose 5 years of their service, my lord. Whereas respective state universities, they are getting 65 years. And in fact, some persons from this institute has gone to other universities within the state, and they will be retired as an adjunct permanently in those institutes. They will be retiring at 65 years. And some professors came from university system to this institute, but due to this age of superannuation, they have retired at 60 years, my lord. After this communication, my lord, the board meeting was held, which your lordship will find at page 87. And relevant portion, lordship will find at page 94. (5.2) Retirement age of faculty and non-faculty staff of the institute. May I read it, my lord? Lordship, probably rise for a moment.
Okay, 5 minutes.
My lords. Of the government rejecting the enhancement of age of superannuation, my lord. At 5.2, lordship will find retirement age of faculty and non-faculty staff of the institute. The director informed the governing body that the government of Assam, by its letter number so and so, dated 28 December 2014, also responded to an important issue passed by 52nd meeting of the governing body held on 22nd August 2014. The resolution passed by the government was GB was as follows. This is a resolution part adopted, my lord. Next paragraph, the government of Assam, by the letter cited above, wrote that the matter relating to retirement age of faculty members and other staff of the institute has been considered in detail. After careful consideration of retirement age of employees of government of Assam, other institutes established by government of Assam, UGC circulars, Supreme Court verdicts, etc. on the subject, it is felt that the retirement age of both faculty members and other staff of OKD Institute, Guwahati should remain at 60 years. The meeting discussed in detail the above response of the government of Assam to the resolution passed by the governing body in its 52nd meeting. The governing body noted that the institute is an outcome of a memorandum of association signed by ICSSR and the government of Assam. Both the parties envisaged the institute to have an all-India character, offering facilities to students and social scientists of a country as a whole, and particularly from any region whose problems would engage the attention of the institute. Further, appointments of faculty at the institute, this is important, were made, assuring them UGC scale of pay following its rules, which include service conditions and age of superannuation. Therefore, sudden change in the service conditions and the age of superannuation will have serious legal implications. In view of the above, the governing body resolved, Sri Bhaskar Borua be requested to take up the issue of service conditions and the age of superannuation of faculty and staff of the institute with the government of Assam, and to resolve the issue taking into account the history of the institute, procedure of appointment it followed during the last 25 years, service conditions and rules of other similar institutes in the country. Now, the other institutes, as I have placed before your lordship, there are 24 research institutes. And all these institutes, there are two types of institutes, my lord. 4 institutes, they are 100% funded by ICSSR. Their age of superannuation is 65 years, which is directly comes under the Ministry of Education, Union Government of India. And in respect of the others, whatever is the age of superannuation in the respective state, that is being followed. And in fact, my lord, in the communication of 2010, the Ministry of Human Resource, then Human Resource Department, has specifically stated that it should be as per the state university norms. That apparently is the discrimination which the petitioner is facing, my lord. All institutes which are co-funded by ICSSR as well as the state government, the age of superannuation of the respective state is followed, except this institute, where in Assam, all professors of the universities, they retire at 65 years. In fact, my lord, medical college professors now retire at 70 years. It is not the claim of the petitioner that it should be 70 years because some professors are retiring at 70 years. The claim is that the petitioner, prayer of the petitioner is that it should be at least make at par with the age of superannuation of the professors of the university system. Because, my lord, in order to have the grade of professor, the same parameters as mandated by UGC is followed. There is not that a professor of this institute is not having the qualifications of UGC to become the professor, to attain the grade of professor. That I'll place the service regulations, my lord, and in the UGC regulations, it is exactly same parameters to be followed. Subsequently, my lord, if your lordship turns the next page, page 96. 4th May 2015, the matter was also discussed. And operative part, lordship, the relevant part, lordship will find at page 97. Service conditions, including age of superannuation. Lordship has got it, man. The meeting had detailed deliberation on the resolution adopted by the governing body in its 52nd meeting held on 22nd August 2014 regarding the service conditions, including age of superannuation for faculty members and service conditions, including age of superannuation for other staff of the institute. The meeting noted that at serial number 3, Lordship may come, the institute has been engaged. The OKD is the result of a memorandum of understanding signed between the government of Assam and ICSSR. The service conditions relating to faculty of the institute must be at par with the university system to attract social scientists to serve the institute. The institute has been engaged in classroom teaching as it has been regularly conducting courses on research methodology, computer application in social science research, etc., and conducted capacity building of the young social scientists involving regular classroom teaching. Further, the institute is going to launch a full-time PhD program involving regular classroom teaching from the coming academic session, since it is being recognized as a research center by the Dibrugarh University and or the Sikkim University. In fact, my lordship comes to page clause 5. Professor Atul Goswami, who served the institute first as professor and then director from 1994 to 2000, retired at the age of 62. 62 was the age of superannuation specified by UGC at that time. In fact, my lord, apart from Professor Atul Goswami, one person, my lord, Professor A.N.S. Ahmed. In fact, there are 2 persons who work in the institute beyond 60 years. The government has allowed them to work beyond 60 years. It is not that no person has worked beyond 60 years in the institute. And to that specific paragraph petitioner pleaded, no response has been in the affidavit. They have filed many affidavits, my lord, that has not been addressed that issue. Lordship, various resolutions are there, my lord. Lordship, I'll take your lordship to another resolution of the governing body, which your lordship will find at page 100. The 55 meeting of the governing body. At 103 relevant portion, clause 4.4, ratification of the government of Assam and ICSSR to the amendment made in MOA of the institute and retirement age of the faculty. Page 103, my lord.
Yes.
The last paragraph. Director placed before the GB the recommendation made by special meeting held on 4th May 2015, which I have placed before your lordship, my lord. The GB once again thoroughly discussed the pertinent issue related to amendments proposed to the MOA of the institute and retirement age of faculty and non-faculty staff. In addition to the recommendations made by the special meeting, the GB also looked into the decisions taken by the GB from time to time since 2005, taking cognizance of the rationale behind the establishment of the institute, the difficulties it has been confronting, and with its requirements, the GB requested ICSSR to expedite the process of rectifying the proposed amendments and to make necessary steps required for resolving the issue of retirement age at the earliest. But the institute by although it has taken the resolution, they cannot enhance the age of superannuation of its own. The funding is like that, 45% of the funding is borne by the state government, 45% is by ICSSR, and the remaining 10%, the institute generates its own funding. This is how the funding pattern works, my lord. If the age of superannuation, unless the state government and ICSSR, they approve these resolutions, the board cannot, the institute of its own cannot, although there are repeated resolutions has been taken, they cannot do it of their own. But state government, they have rejected again, my lord, subsequently. And ICSSR, their stand on affidavit as well as in documents annexed with the writ petition is that they will go with the state government, my lord. Whatever the stand taken by the state government, they will stick to that. Lordship, one more document Lordship may kindly look into at page 109. Which is the minutes of 59th meeting of the governing body, which was held on 16th of August 2017. And the relevant portion is at page 114. The last paragraph, clause 4.8, towards bottom, my lord.
These are all resolutions
Yes, my lord. The board has been taking resolutions, my lord,
on and off.
on and off. And in fact, my lord, I'll place your lordship some documents. What difficulties the lordship, it is a policy decision, I understand, my lord. The government has not increasing the age of superannuation. But my submission, respectful submission is that the denial of the state government on affidavit is that the institute is not an educational institute, it is a research institute. Therefore, the benefit of enhanced age of superannuation will not be applicable. But that classification of a professor of an educational institute and a professor of a research institute, in my respectful submission, is not a reasonable classification.
What is the reply of the state law?
They have filed that is their affidavit, my lord. And our reply, we have filed that classification is not at all a reasonable classification. Once a person attains the grade of professor, that professor, the qualifications laid down by the UGC is also same in the institute. Even if he is a professor in the institute or he is the professor in the university system, there is no distinction, my lord. And the petitioner, already there are a number of research scholars. As many as 3 persons has been awarded PhD under the petitioner. And 4 persons, they are undergoing their research under the petitioner, my lord. The same works they are doing, except that some regular classes and certificates they are not offering, my lord. Lordship, kindly turn to 119 for a moment, my lord. The 2 documents I will place, my lord. Which was issued, a representation was issued to the Additional Chief Secretary, Transformation and Development Department. This is the department which controls the institute. It is not under the Education Department. The institute is controlling authority is the Transformation and Development Department. Regarding age of retirement of faculty at the institute. Sir, kindly refer to, Lordship may kindly come to the second paragraph. Matter was discussed with you in detail and suggested we try to obtain procedures followed by other institutes established by ICSSR and other state governments. Accordingly, we had discussed this matter with the other institutes and we have found the following. In case of 4 institutes located in Delhi, which receive full financial support from ICSSR, the respective governing body, executive body adopts the retirement as per UGC regulations for the members of the faculty, which I have already submitted, is also specifically mentioned in this, my lord. And at B, clause B, in case of the institutes which receive financial support from ICSSR and the respective state government on 50-50 sharing basis, the governing body, executive body adopts the retirement age for the members of the faculty following the rules practiced in the respective state universities. Here, my lord, the respective state universities, as already Lordship knows, my lord, is 65 years. And discrimination is only with regard to the institute, my lord. They are not giving the benefit of 65 years. The Ministry of Human Resource Development in year 2010 has specifically stated that it should be as per the respective state university norms. But only in respect of the petitioner's institute, where the petitioner is working, it is kept at 60 years, my lord. Lordship, one more document, my lord. Lordship, may kindly turn to page 120. Now, why I am placing these documents is that what the institute is facing, the difficulties faced by the institute for keeping the age of superannuation at 60 years. But my submission is that the institute was established by the state government and ICSSR. I'll place the aims and objectives, my lord. There are definitely there with some aims and objectives. The objectives which were sought to be achieved by the state government and ICSSR by establishing the institute will not be achieved if the age of superannuation is kept at 60 years, my lord. It was issued on November 17, 2020 by the director in charge, who is presently also the director in charge, my lord, of the institute. Lordship has got page 120, my lord. Lordship, I'm reading from paragraph 3, my lord. You are perhaps aware that the institute came into being in 1989 under the joint initiative of the state of the Indian Council of Social Science Research and the government of Assam. The faculty members of the institute are appointed following qualifications laid down by the UGC rules and regulations from time to time, along with UGC scale of pay and service conditions. This was necessary to give the institute an all India character, allowing people from different universities and academic institutions to come to the institute at ease. In fact, during the initial decades, the institute's faculty included people who came from universities on lien and subsequently got permanently absorbed. From the very beginning, the institute followed UGC service conditions, including retirement age for faculty, and 2 of its professors got retired accordingly. I mentioned, my lord, Atul Goswami and Professor A.N.S. Ahmed, my lord. They retired beyond the age of 60 years, my lord, from this institute. the issue of retirement age of the faculty of institute came into discussion in the 52nd meeting of the governing body held on August 22, 2014. When the matter was placed in connection with the implementation of Sixth Pay Commission recommendation, it was resolved that the retirement age of faculty members of the institute would be as per UGC regulations. The government of Assam, however, informed the institute in its view by letter number so dated December 20, 2014, that the retirement age of the faculty of the institute should be 60 years. Ever since, the issue has been discussed in all the meetings of the governing body held subsequently, and as discussed, repeated appeals have been made to the government of Assam to reconsider the decision in the greater interest of the future and growth of the institute. Appeals have also been made, at least to make the retirement age of the professors of the institute at par with the professors of state universities. Till date, the final decision on the issue is still awaited from the government of Assam's end. Meanwhile, one professor had to take retirement after attaining 60 years of age. One professor came from Guwahati University, thereafter permanently joined here, my lord. She got retired at 60 years. In fact, the vacancy which arose due to retirement of that person is still not filled up, my lord. No person is coming to the institute to join as professor as on date because of this disparity of the age of superannuation, my lord. Why somebody would come from any university to join here as a professor where they will lose 5 years of service? This has resulted in a major hardship for the institute in terms of its present functioning and future growth. Now the institute is caught in twin dilemma. On one hand, it is not being able to retain existing faculty members, and on the other hand, it is not being able to attract senior level people to its faculty, that is at the level of professors from universities, where the retirement age is already 65 years. As the institute already suffers from small faculty, the issue of retirement of faculty has only been made things difficult for the institute to operate effectively, fulfilling the mandate given to it. Recently,
Basically, your prayer is that you should be given 65 years.
65 years, my lord. Why, my lord, I am saying that is that
On what basis?
my lord, it is I have placed before your lordship the communication which was issued by Ministry of Human Resource Development at that point of time in 2010, that it should be as per state university norms. Here in the state universities, people at the grade of professor, they retire at 65 years. But in this institute, professors are getting retired at 60 years. In fact, my lord, other institutes of similar nature, which are funded by ICSSR and the respective state governments, they follow the age of superannuation of the respective state universities. That documents I have already placed. And the ground taken by the authorities, basically the state government, in denying the benefit is that it is not an educational institute, rather a research institute. To which, my lord, my response is that research is essentially a part of education system. It is not that only educational institutes where regular classes are conducted, where degree is given, only those comes under purview of education, my lord. All educational institutes may not be a research institute, my lord. Like a school or college may not be a research institute. But all research institutes which involve in research and policy matters, they are also an educational institute. And that discrimination, that classification, that sought to be made by the state government while denying this benefit is not at all a reasonable classification. And in fact, my lord, in the service regulations also, it has been provided.
Right.
As it plays, Lordship may kind to page 164.
Yes.
This is the Omio Kumar Das Institute of Social Change and Development Services, Faculty and Other Academic Staff Regulations. Relevant part, Lordship, will come to page 177. Mala, before that, I'll pause for a moment and say that faculty, the term faculty used in this regulation, there are three types of faculties: assistant professor, associate professor, and professor, my lord, as per the service regulation. The age of superannuation of all faculty and academic staff of the Omio Kumar Das Institute of Social Change and Development in its permanent full-time service is 60 years / as notified by government from time to time. So my submission to this is that as faculty includes assistant professor, associate professor, and professor. In respect of assistant and associate professors, it will be 60 years. And in respect of professors, it will be as notified by Government of Assam. In fact, my lord, Government of Assam has already notified the age of superannuation of professors to be 65 years. At page 78, my lord, Lordship has already perused the notification. And their stand is that it is not under education, this institute is not under education department, therefore that notification is not applicable. Whether the institute is not under education department or transformation department is not within the control of the petitioner. Ultimately, my lord, a cabinet took a decision. That decision of the cabinet has been communicated by way of a notification. And the works performed by the petitioner in the institute is exactly similar to that of a professor in the university system. So in that view of the matter, the petitioner cannot be discriminated solely on the ground that, my lord, this is a research institute. Lordship, kindly take that affidavit I have filed, my lord. Additional affidavit. Lordship has already perused. Lordship, turn to page 451 for a moment. Here, Lordship has seen the communication issued by the Ministry of HRD. 451.
Yes. No,
My lord,
1 minute only.
the institute has taken, this is an agreement memorandum of understanding of the institute in Dibrugarh University. This is the recent one, my lord. Prior to that also there was a memorandum of understanding. Petitioner has annexed the recent one. Purpose: Guwahati University is an affiliating university which awards PhD, which award degree of Doctor of Philosophy. And whereas Omio Kumar Das Institute of Social Science is an autonomous research institute of ICSSR, and Dibrugarh University has already recognized the institute as a research center in art. And Omio Kumar Das OKD is an affiliated research institute of Dibrugarh University to undertake full-time PhD program, fully adhering to Dibrugarh University regulations for Research Council, and for degree of Doctors of Philosophy 2019. The Dibrugarh University and Omio Kumar Das recognizes the mutual collaboration given to each other. My lord, collaboratives are there. Lordship will kindly see what kind of research, conduct of research program at page 453. Prior to that, my lord, Lordship may turn at page 452, my lord, at clause E. DU and OKD shall share human and other resources available with them in respect of PhD research programs on mutual agreement, specialized and short duration refreshers courses, training programs on topics of interest or to academia.
This is between you and Dibrugarh University.
Yes, my lord. The Dibrugarh University has recognized, my lord, responsibility of the institute. The Dibrugarh University shall extend Amiyo Kumar Das full recognition for conducting PhD programs as per Dibrugarh University Research Regulation for Research Council and for PhD degree. To recognize Amiyo Kumar Das Institute as a research institute affiliated to it and shall create provisions for full-time PhD program in the institute in compliance of the Dibrugarh University Regulation Research Center. Conduct Dibrugarh University Academic Research Admission Test for enrollment of students in Amiyo Kumar Das Institute of so-and-so, also in which subjects the university permits institute to conduct PhD program. To maintain coordination with Amiyo Kumar Das for conducting PhD program, including PhD pre-registration courses, etc. So basically, my lord, the petitioner, the institute in which the petitioner is working as a functioning all the activities of a may not be giving degrees and diplomas, my lord, does not preclude this institute to become from the purview of educational institute. Just because the term research institute has been written, it is a research institute, it cannot be said that research is not a part of education, my lord. And in fact, my lord, the service regulation has clearly stated that it should be 60 years for faculty or as notified by government from time to time.
That I've already seen.
And time to time, my lord, government has already notified it to be 65 years.
But that in that there was a writer.
Lordship.
That one there was where that page 78.
Page 78, my lord.
Please clear and specific. Yes. It was decided to raise the age of retirement of all professors of education institution, including medical college, after 65. It is clear and ballot prominent.
That is why petitioner is saying, my lord, educational institute. A research institute is also an educational institute, my lord. It cannot be discriminated just because nomenclature is given as research institute by itself will not preclude that institute from educational institute. Or just because of the fact that the controlling authority is not the Department of Higher Education, rather it is the Ministry of Transformation and Development. Lordship will have to see what kind of activities the institute is performing. For that, Lordship will kindly see the aims and objectives from the Memorandum of Association of the Institute.
Yeah, that I've seen. That I've seen.
Lordship,
That I've seen.
the memorandum is at page 43, my lord.
Hmm. Yes.
This is the Amiyo Kumar Das Institute of Social, sponsored by Government of Assam and Indian Council of Social Science Research. At page 44, clause 3, aims and objective. To undertake, aid, promote, and coordinate research on problems and process of social transformation and development of Assam and other states of northeastern region, and to contribute to the formulation of strategies and programs for speedier regional development, to provide academic and educational professional guidance to agencies, institutions, and scholars engaged in research in social sciences development, to offer on request advisory and consultancy services to Government of India, the Government of Assam, and other state governments of the northeastern region, universities, colleges, and other educational institutions and organizations in business, industry, or trade, to act as a clearinghouse of ideas and information on research in social science, with special emphasis on the problem of Assam and other states of northeastern region, to document, disseminate information on culture, socio-economic life of the region.
That I've seen. I've seen.
And in fact, my lord, this institute publishes a journal of social change, which is a peer-reviewed journal by the UGC, recognized, my lord. So activities which are being performed by this institute may not be in strict terms related to conventional education system, but ultimately, if your lordship sees, the same activities are being performed by the institute. Irrespective of that, my lord, by page 205, the state government has again rejected the claim of the petitioner, my lord, the institute, my lord, rather. Page 205, proposal for raising the age of retirement of professors of Amiya Kumar Das Institute of Social Change and Development. With reference to the letter on the subject cited above, I am directed to inform you that the government in Transformation and Development Department regrets its inability to agree to the proposal for raising the age of retirement of Professor of Amiya Kumar Das Institute of Social Change and Development. But this communication, along with the communication of 2014, is under challenge in this writ petition, my lord, whereby the claim of the institute has been declined.
Okay.
And mainly, otherly, one thing, my lord, I have already placed how Article 14 has been violated, that there are 24 institutes, and all the institutes follow the age of superannuation of the respective states, except this institute. And there is no explanation given why this institute has been singled out, and why this petitioner institute in which petitioner is working is not entitled for similarities in treatment. In the affidavit, my lord, the only stand is that the opinion of the education department was taken, and education department that has stated that it is not a educational institute, as it is not mentioned in the memorandum of association. Whether it is mentioned in the memorandum of association or not is that one thing, and what are the activities that are being performed by the institute is to be required to be taken into account, my lord. And secondly, this kind of classification was not there, my lord, in earlier point of time. Only after filing of this petition, they have come up with that affidavit and said that we are classifying this institute to be a research institute, whether such a classification is reasonable, whereas all the activities are being performed are similar in nature, my lord. One thing I'll like to place before your lordship, under service regulations, what are the conditions required to attain the grade of professors vis-a-vis the UGC regulations, my lord? In fact, the service regulations has all throughout stated that it will be as per UGC regulations and as notified by the state government. Lordship will kindly take page 185 for a moment. This is under the service regulations. Eligibility, professor, an eminent scholar having PhD degree in concerned relevant discipline and published work of high quality, actively engaged in research with evidence of published work with a minimum of 10 research publications as books and or research policy papers, and a total score of 120 as per criteria given in table 2. A minimum of
No,
10
these
years.
are the eligibility criteria.
It
only.
is same as that per, my lord, for professor.
That may be there. That
Yes.
may be there.
It is not
But the
that.
problem is you're a research institute.
Yes. This is admitted, my lord,
So
but
that
whether,
part only we have to consider
yes,
whether the classification made by the respondents. is-
exactly that is precisely, my lord.
That's
Whether
the whole
that
thing.
classification, my lord,
There's
is-
no need to go too far.
my lord. My respectful submission is that once, my lord, a person attains the grade of professor, further classification of a professor as a professor of research institute and a professor of educational institute is not justifiable. And secondly, just because, my lord, the institute is a research institute, it cannot be said that the research and education both are separate things. Well, all educational institutes may not be a research institute, but all research institutes are also educational institute, my lord. And one of the arguments, my lord, one of the pleadings, my lord, in the affidavit is that the institute does not award any degree or diploma. Therefore, it is not an educational institute. My lord, in normal conventional mode, a school does not give degree or diploma or college. It is given by the university. Nonetheless, the school is an educational institute. If that argument,
Oh, that's a different issue.
well, they are saying that it is not giving any degree or diploma, therefore it is not an educational institute.
These are not different things.
And secondly, my lord, all the institutes which are funded by ICSSR and the state government, they are following the respective state universities, my lord. That is on record. And the central government has specifically stated way back in 2010 that it should be as per respective state universities. So why the similar treatment will not be given? Subject to what the respondent said, there is an amicus also, my lord. Amicus was also appointed.
The respondent conclude, and then I will address your lordship on, my lord, next Tuesday, my lord. Today I have a matter fixed at 2 o'clock. So can it be on Tuesday, 6th, 5th?
Yes, Chutia?
Today,
Yes.
and another thing, my lord, on the last
can
occasion,
start.
this honorable court was pleased to direct them to produce the cabinet decision. I mean, the records of the cabinet meeting. Ultimately, everything, my lord, processed from the cabinet decision. It is just a one-liner which has come on record. What was the discussion, how and on what basis?
You have the
The
record.
I have received last occasion, I was asked, the letter communicated them to, it is negated. That has been disagreed letter has been, I have received. It's a Chief Minister's letter. On the basis of that, my lord, that has been communicated to them. No, your previous announcement of age 60 to 65 is regretted. Not a. This is Chief Minister, my lord. I'm not angry.
No, my lord.
I'll put it.
Issue,
Not the.
my
And
lord,
cabinet
that
decision is taken in the.
is a decision, but my lord, the discussion, how the decision, what was the object, what was the reason for arriving at?
That's the cabinet memorandum.
Yes, my lord. That was
That
directed to
precisely
be
was.
produced, my lord, long time back.
So first of all, my lord, before producing all
Because-
these things, my lord, petitioner has to establish the educational institution. He is arguing, I have heard it, my lord, only somebody is given, somebody is not given, somebody is getting, somebody is not getting. That is not a my lord, his argument. Argument should be pointed out. He is an educational institution. He established it is an educational institution. How it is educational institution? It is a CM my lord's order.
No, the cabinet memorandum that led to the cabinet. meeting.
Memorandum-
Because ultimately, my lord is examining whether it is a reasonable classification.
That he produced the cabinet.
Cabinet memorandum, my lord, I don't think my lord cabinet directly any memorandum, my lord. That has-
How can there be a cabinet decision?
No, my
that doesn't-
decision has been taken in the my lord proposal, that has been taken in the my lord, house of the my lord, in the residence of the CM. That is, they have decided, and our exact resolution is with us. We have annexed in our affidavit. Now petitioners, my lord, I will have to go through it. My lord, petitioner is a purely research institute, my lord.
No, that's fine. That's fine. That they are admitting also.
Mere nomenclature of professor, it does not mean he is a under educational institution. He is not
The
in this
cabinet
institution.
meeting held on 19/9/2012.
Yes.
That cabinet memorandum I want to see.
My memorandum, I don't know my lord, whether the memorandum is or not, but the decision is a memorandum. Copy of this, my lord, our affidavit is there, my lord. In our affidavit, we have an additional affidavit.
Okay. I'll direct you to get the cabinet memorandum. But
In fact,
Mr.
that was already directed, my lord.
Learned counsel for the petitioner as well as Mr.
S. Chakravarti.
S. Chakravarti, learned amicus curiae. Stop. Mr. T.C. Chutia, learned additional senior government advocate, shall produce the cabinet memorandum in connection. It's 78.
In connection with the cabinet decision.
In connection with the cabinet decision taken on 19/9/2012 for raising the age of retirement of all professors of educational institutions, including medical colleges, to 65 years. List on,
As per Lordship Corbett, my lord. I have no plan.
when can you get it?
Oh, today is the Malaka 29. Lordship just kept the matter and it was parted.
Huh?
21st March.
Okay, 21st March as parted. Yes, I don't think I have that.
21st March.
Doctor, today there is a big problem. Up to item 14, 1 to 14, this has to be spoken to. That is at 2 o'clock.
Yes.
And at 2, I have a division bench. So single, I'm sitting only up to 1.
Rest matter will be separate.
Lordship may in that case fix some other day,
You can give your convenient day.
on 7th.
Oh,
Or,
7th, there'll be some problem.
or on 26th,
26th March
yes.
is a holiday.
Oh,
How about between 18 to 22nd?
then on 18th itself, or on 21st,
Okay,
21st.
but Mr. S. Datta, senior counsel for the petition. Is it S. Datta, is it? No, M. Datta, M. Datta,
Yes.
S. Datta. List the matter on 21st, you want, 21st of March.
It will come as parted.
Yes, parted.
Lordship, item number 44 and 45.
Hmm.
These two matters has been adjourned today
Hmm.
for 2 weeks. The thing is that I have not been informed with regard to this matter. Lordship probably remembers this case. This is with regard to the appointment within NIT. And there is a stay order the petitioners are enjoying. On the last 3 occasions, whenever the matter has been listed, it has been adjourned on this and that pretext. Today also it has been adjourned, but I have not been informed. Since morning I'm waiting here. I have not been informed. Even the copy of the affidavit has been served to me, but I have not communicated that this matter has been adjourned in the morning. So there is some extreme urgency in the matter, Lordship, because the all India level exam, everything has been halted because of the pendency of the writ petition. And there is a settled judgment of this honorable court also that cannot be regularized in a short process. So can it be taken up on Monday, Lordship?
44. Not Monday, not next week.
Lordship,
We'll
because the
have-
urgency is
we'll
there,
have
Lordship,
it on
because
ele-
this
we'll have
model
it on-
code of conduct will come into play, then these persons will not be taken into account. The persons who had participated in the selection process, Lordship.
That we can help it. That we can help it.
Because the last 2-3 occasions, the matter has been adjourned, and today also, Lordship, in the morning.
Where's Barua? He is the
Yes,
one-
Lordship, in the morning when the matter has been adjourned, I have not been informed. Even the copy of the affidavit has been served to me, Lordship. So this practice is not good.
And
otherwise.
that was
Because I
not,
should have been
that was
informed
not
about
on
the fact.
record. MG Barua.
Exactly, Lordship. He has served me a copy of the affidavit, Lordship, but he
Bring
did
him.
not inform me.
Bring him.
Lordship can take it up in the next week, Lordship. Any date in the next week. I'm not pressing for Monday. Any date in the next week, Lordship.
Any date in the next week. This is some problem next week. That's why I'm telling you.
Because otherwise,
Okay, list, because list on 6th.
6th.
March.
Well,
Obliged,
item 17, instead of 21st, can it be 12?
Okay.
Item 17, 12.
Yeah.
Obliged.
Lordship, item 21, will it be taken today, Lordship, if there is some urgency?
Today, there's no problem, there's no time.
Tomorrow? Second half,
Second half, I'm having division bench.
then it may be taken up tomorrow, Lordship. It is admitted case, Lordship. Under PWD category, she was selected, Lordship. After that, the medical board has stated that she had only 13% disability. Now AIMS has stated that more than 90% disability she has. And now they have filed an affidavit, Lordship, wherein it is admitted that her disability may be progressive, and it is admitted that the AIMS report is admitted, Lordship. So this is a simple case, Lordship, and she is not appointed till that
Monday.
Lordship.
My lord, in respect of item number 46, my lord, I need to speak due to urgency. There are review petition, my lord. What happened, my lord, due to the compliance order passed by the respondent, my lord.
Okay, on request made by K. List on 13th.
13th in the fourth, my lord.
My lord, item 47, this is a matter of 2008, my lord.
Hmm.
As a 2008 matter,
Hmm.
the grade 4 workers have been suffered
Hmm.
due to some order. It may kindly be taken as early as possible, any day in the next week.
On request made by MB Mahmood, Leonard Council for petition, list on 12th March.
Lordship, in 21, they have filed an affidavit, respondent number 8. It may be calling for record of it.
That we don't know.
Today,
So if you have got today, tomorrow it will not be on record. There is no point having it tomorrow, on Monday also.
Lordship, it may be taken up the Monday.
Okay.
My lord, in respect of item 47, Mr. Mahmood made a mention.
Hmm.
My lord, the series, my lord, series matter, my lord, all pending cases,
Hmm.
hearing matter, my lord, Lordship has fixed the matter on 12. 12 is a my lord motion day. If it is possible, my lord,
47.
47, there's a series, my lord.
Huh.
My case is, my lord, item number 50
Hmm.
in that series.
Hmm.
Can it be fixed on a hearing day, my lord? All pending matter, my lord, hearing cases, my lord, on a motion day,
What date was it fixed?
it was 12 of March, my lord.
12th March. It's a hearing day,
12 March is, my lord,
Tuesday.
sorry.
Item 1 of daily list.
Wait, is it?
Hmm.
My lord, I am a bit embarrassed. My lord, I could not yet make the matter ready. Well, the written argument to write is the biggest tough job for us.
I know.
My lord, a little bit of time maybe.
Yes, that's that. Then the senior counsel, maybe respond us. When do you want?
After 2 weeks.
Short date may be, a date may be fixed, Your
I
Honor.
have to fix a date,
Yes, Your Honor. 2017 matter, Your Honor.
28, 29. How about 18th?
Yes,
18th March? Okay.
I believe I'll make it.
Doesn't matter, if you need time, we'll.
My lord, much of.
Obliged.
Item 2.
My pleasure, Lordship. Lordship, in this matter, I have discussed with the councils of other sides. We are ready to re-hearing, Lordship. Lordship, kindly fix it after 19 March.
Third MS,
R. Kakoti.
or Kakuti, then the council for the petition. We are petitioner.
Yes, Lordship.
Stop. This matter is released from Parliament. This matter is released from, what you call, it's released from CV. And this the matter for hearing again on when?
19th
19th
March.
Okay, 19th.
3.
May it please your lordship. Lordship, written argument on behalf of the petitioner side is ready, lordship, to be submitted.
Year four,
And for 4, 5, and 6 respond.
and how about 1, 2, and 3? Where?
This is the Upomon is appearing, Lordship.
Huh?
Upomon is appearing, Lordship.
Uh-huh.
Thought that the division should pass. I'll inform him, Lordship. I have no idea.
Wait for some time.
I'll
Inform him now.
Yes,
Your division bench will have to sit again.
yes, Lord.
4.
For petitioner, that's fine.
Lordship, on behalf of R. Majumdar, your lordship, lordship, written argument will be,
R. Majumdar,
lordship, will be filing it by Monday, your lordship. For the written argument, your lordship.
is it?
Lordship,
Okay.
by Monday we'll be filing it. And also for 5s,
Third, Mr.
Didas.
He does, then a council for petition on request made by R. Majumdar, the council, something council,
lordship, for secondary education.
secretary education, please. We'll have it on 11.
Lordship.
11.
Lordship, for same prayer for 5, 6, and 7, your lordship.
No, 1 minute, one.
Lordship,
You keep it.
5, 6, and 7.
I'm approved for 6.
5 and 7, we are ready for written argument.
Okay. You're good now?
And that Chaudhary on behalf of Mr. Priya.
Okay, I'll just record here, Bhuyan. But here, Bhuyan, then it comes with the petition in WC 5279 of 2020 and 3575 of 2020. Okay, as well as MS.
And the item number 6. Argument is ready, Roshan.
For WC 605. On request made on behalf of Mr. R. Majumdar, the understanding of higher school education.
Lordship, school education.
List on the same day,
Lordship.
11.
Given this date, 11. Obliged, Your Lordship.
8 and 9.
Today is the fourth occasion, my lord, it has been listed for to be spoken to, my lord. I am ready with the written
Go with
argument.
the other side.
State respondents, my lord, the
Elementary.
elementary education department, my lord. Proceed to decide the matter on the basis of buildings available on record.
No, okay, let us wait. Elementary.
I may be allowed to call Lordship.
Yeah, 1 minute.
Ma'am.
10 to 13.
In this matter, I appeal for the governing body of the college.
Hmm.
Now, in the item number 11, my lord, that was the first writ petition. The challenge was made to the constitution of an internal complaints body. Now, recently, my lord, on this is for the 19th of October 2023, we have the governing body has passed a resolution to revoke that particular internal complaints committee resolution. So the entire series has now become acceptable.
Where's the petitioner's council?
Mr. S. Chakraborty, he appears.
We listed on 11th.
Ma'am,
On
because I'm filing an additional affidavit to place this on record on that particular ground.
non appears for the. This is the matter again on 11th. 11th we listed.
Ma'am. Okay.
14. 14.
11th. Okay, none appears for the parties. List on 11th.
15.
In this matter, the writ petition are already, the written argument are ready and file on behalf of the written writ petition.
Lordship, I'm appearing on behalf of my senior for respondent number 3, Lord.
Who's your senior?
Lordship, Mr. N. Bora.
You're ready?
Lordship,
Ready with the arguments?
no, not yet, Lordship.
Okay. Heard, Mr.
Arkenath.
Arkenath, legal conflict of petitioner on request made on behalf of Mr.
N. Bora, Lordship.
N. Burrell, legal counsel for respondents, 3 and 4.
Lordship, 3, as shown in the cause list, Lordship.
List on 11th. By that day, you get your arguments ready.
Lordship,
You're listing it on 11th again.
11, Lordship.
In the meantime, I want to start.
Keep it.
Lordship, 3 and 4, yes, Lord. 3 and 4.
Yeah. Pull out again.
Item 3.
You're petitioner.
Yes, Lordship.
You're ready.
Yes, I am ready.
For respondent 4, 5, and 6 ready.
I am for the 7, my lord.
Yeah.
Argument is ready.
How about higher education? Bhuyan.
Informed.
Then I listed on 11th.
Yes, Lordship.
Heard, on request made on behalf of Mr.
D. Povinno.
D.
D. Upamanyu.
Upamanyu, Learned Standing Council Higher Education, list on 11.
Not subject.
8 and 9.
Elementary,
Yes, Lordship, within a week, we will file our written arguments.
huh?
Within a week, we will file our written arguments.
Third teacher, on request made by MS,
S four,
Cornwall Learned Standing Council,
Lordship,
elementary,
elementary.
list on 11.
Possibly observe that, my lord, on the
Yeah.
on 11, my lord, if the Jurat file, my lord.
I'll proceed on the matters available on record.
Item 42 and 43, Lordship, date is on 7th of March, Lordship. Item 42 and 43, Lordship. The date is not fixed, Lordship. There is urgency, Lordship. 42 on a review petition, Lordship. On 7th of March, Lord. 7 number of vote cases, sir. Vote cases. Hearing the. Or 12th of March.
When do you want?
12th of March. On a hearing day, Lordship. 12th of March, 42 and 43. Replayable. 42 and 42.
Item 1 of daily hearing.
In light of your lordship's judgment dated 2 February 2024, passed in the writ appeal 250 of 21. I don't have a case anymore.
Already issue decided, your lordship's order, that now seniority will be again
Accept So I
redetermined, my lord. So this case is follow that exercise. It is your lordship's order.
Lordship has allowed it, except the appellant in this particular matter.
Then you say this case is covered by the judgment?
Yes.
And therefore what direction has been passed will be followed in this week.
Yes.
Okay.
Yes.
Like that will pass the short online order. Then I'll pass the orders.
My lord.
Third, Mr.
P. Bharadwaj.
B. Bharadwaj, Learned Counsel for the appellant. Also heard.
MJ Burua for response.
MJ Barua for the
Private respondent and
no. Union of India.
she is in.
No, I am not Union of India. For the rubber board, Mr. D. Nath is appearing for respondent 2, 3 and 4.
Mr. I'll record his name.
Yes, sir.
Oh, you want your name?
No, I am not in the case, Lordship. I am just appearing on your behalf.
Okay, and Mr. D. Nath, Learned Standing Council Rubber Board for the respondents 2, 3 and 4. And Mr.
5. MJ Burua for 5.
MG.
MJ Burua.
Barua, Learned Counsel for the response number 5. Stop. Learned Counsel for the parties submits that this writ appeal is covered by the judgment and order.
2nd of February. At this time.
Dated 2/2/2024. Passed by this court in writ appeal number 250/2021. Stop. Do we need to further reiterate? Not required.
No.
Accordingly, Papa. This writ appeal is disposed of by directing that the parties shall abide with the directions passed by this court in writ appeal number 250/2021.
And 350 and two writ appeal. It's the
Okay.
common judgment.
Common judgment. In this common judgment it is
25035
2024 passed in 250
and
2021 and
357.
and 337 of
337.
2021. You make that correction. Can I keep retain this?
Yes. Obliged.
Okay.